We were in court this week on the Clinton email and Benghazi scandal. Oh yeah, that's all over, right? It is not over. If you want to know why the president is being impeached, look at the Clinton emails. It's all designed to protect her from prosecution, in my view. How do we distract the Justice Department? How do we distract the American people from holding Hillary Clinton accountable for her crimes when it's obviously the FBI, the Comey, corrupt FBI, the Justice Department, the corrupt Obama Justice Department, rigged that investigation to protect her? What do we do to fix that? How do we protect her from accountability with the new Justice Department? Let's push this Russia smear. Let's try to put President Trump in jail instead and ignore the corruption. Well, thankfully, the courts haven't ignored the corruption because of this court specifically in this case. We had asked for Hillary Clinton's emails in the Benghazi issue, and that's how we uncovered the Clinton email scandal. They were forced to admit they had the hidden Clinton emails because of pressure from our attorneys. And long story short, the end of last year, we received the permission to conduct discovery, gather evidence. That means get documents, bring in people for testimony, serve interrogatories, which requires sworn answers under oath. We deposed nearly 20 witnesses, had lots of interrogatories. We had all sorts of confirmation of further misconduct by not only the Justice Department and the State Department, but by Mrs. Clinton. So we've been getting this discovery all over the objections of the Justice Department and the State Department. And no, not the Obama State Department, not the Obama Justice Department, but this administration's Justice Department and State Department. Mike Pompeo, Attorney General Barr, they're running those agencies. Or are they? So we had a status conference this week because we're still seeking Mrs. Clinton's testimony and the testimony of Cheryl Mills, her top aide, who was not only her senior, I think her chief of staff at the State Department, but then she became her lawyer and she was involved in the destruction of these emails. We want some other discovery of other State Department officials who knew, evidently, based on their other testimony, about what was going on. Plus, we wanted to subpoena Google and her top aide, Paul Combetta, who supposedly had taken all of her emails and sent them to a Google email account. We want to figure out if those emails are still around. So that was on the plate. So we go into court. Our lawyers on this case are Ramona Kotka, who you may have seen on our YouTube channel, and Lauren Burke, who's another Judicial Watch attorney who's also been on this case. She's handling another Clinton email case, another big Clinton email case as well. So you got the two attorneys there for us, and then me. I'm the client, so I'm sitting there, and I'm supposed to I'm there as the corporate representative, representing the client, and so I'm representing you in that regard, aren't I? And so I have to sit there and watch this. I'm not a lawyer, so I don't get to stand up and make objections and make argument. And what happens on the other side? The Justice Department and State Department send in 6 government attorneys. 6. And they're not junior guys. They're not junior at all. Senior Justice Department and State Department attorneys. 6 government lawyers to try to shut down our questions about this email issue and Benghazi. You have, as of 2 days ago, the Justice Department and State Department protecting Hillary Clinton in court over her email misconduct. And in addition to that, Mrs. Clinton had her personal attorneys there, 2 of them, and Ms. Mills had 2 of her attorneys there. So that's 6 plus 4, 10 attorneys, all on the same side against Judicial Watch. And of course, the court isn't intimidated by the number of attorneys. He had questions because I've disclosed to you how in Lauren's case, where we were asking for all of Hillary Clinton's emails, not just the ones related to the Benghazi talking points, that the FBI turned over new documents, new emails they found to the State Department. The State Department looked at the emails and said, oh, there are 30 new emails here. This is years after they told us they had turned them all over to us. And the judge is like, well, what's going on here? And the response from the Justice Department, we don't know. We don't know where they found them. We can't give you the information. It's really hard to figure out. If you think the abuse of the court process is limited to FISA, you got another thing coming. We see it regularly. So I don't know how the court's going to rule. He didn't rule from the bench. But Ramona, who did the arguments for us, did a great job. But I just want to let you know that we're fighting right now, the Justice Department and the State Department right now, on Clinton's emails. Now that's frustrating. That is really frustrating. It doesn't slow us down. We don't pull any punches. You know, because we defend the President of the United States over the criminal targeting of him, it doesn't mean that we pull our punches with the Trump administration generally. I want you to think about this. I guarantee you, no one else has sued the Trump administration or is in court against the Trump administration on more lawsuits than Judicial Watch, as we try to get access to information. Oftentimes about the deep state, in this case about Hillary Clinton and the State Department and its current misconduct, State and Justice Department's current misconduct. No one sued the Trump administration more. And I suspect the president would be outraged when it's put, if it were put like that before him, I'm sure he'd be outraged. Can you imagine, if I were the President Trump, I'd be blowing my top to learn that my Justice Department attorneys are in there defending Hillary Clinton and trying to stop Judicial Watch from obtaining what the court wants information on, the level of corruption and misconduct surrounding the Clinton email issue. If I were the president, I'd be blowing my top, and I'm sure he would be. If he sees this, he'll probably blow his top. But we're going to keep on fighting, and we'll see what happens. We're getting new Clinton emails. We just exposed, for instance, that the Justice Department and the State Department hid until just a few months ago smoking gun Benghazi emails that show that they all knew Hillary Clinton had a private email account and she was using it to talk about Benghazi. And if it had been disclosed in a timely way, it would have exposed the whole scam. But they hid it not only in the beginning of the scandal, but up until Judicial Watch forced them to turn it over to us. As I keep on saying, the heavy lifting does get results. And it's not perfect accountability, but we would be nowhere but for Judicial Watch. Absolutely nowhere. On the IRS scandal, as I said last week, this FISA-gate scandal, this IG report, if you've been following Judicial Watch, you've known all about the scandal in large measure. There are additional details by the IG, but the big picture, Judicial Watch already exposed through our FOIA litigation. Fast and Furious, you name it, IRS scandal. Benghazi, no select committee without Judicial Watch. And of course the Clinton email and pay-for-play scandals. We didn't do this for this result, but the consequence of our exposing this scandal led to Mrs. Clinton losing the presidency. And it ain't over. And yes, we're on these other scandals with Ukraine and Joe Biden. And I just said Adam Schiff we're suing. So Lord knows what else we're going to find.
Also, attorneys for former National Security Advisor Michael Flynn today saying they plan to ask a federal judge to dismiss the criminal case against him altogether because of what they call egregious government misconduct. That in a filing today, his defense attorney, Sidney Powell, alleging federal prosecutors buried evidence, including edited FBI 302 interview notes that could exonerate her client. We'll be taking all of that up in detail with Sidney Powell here tomorrow evening. She's among our guests. We hope you'll join us then. And joining us tonight, Tom Fitton, president of Judicial Watch. Tom, good to see you. And let's start with, first of all, Sidney Powell's defense of General Flynn. It looks as though there has been an absolutely atrocious miscarriage of justice against the general.
Oh, that's for sure. And the Justice Department, even worse, is defending the indefensible and saying that anything Sidney Powell's saying can't be taken with any veracity or any seriousness by a court. In this case, Judge Sullivan. I don't know what's going on over at the Justice Department, but if I were the Attorney General, in the least, I would freeze the case to examine the issues of misconduct. Because you can bet Judge Sullivan in the long run, I think, is going to take a look at this case and demand some accountability from the Justice Department. And Attorney General Barr needs to get ahead of the ball here and take some ownership here and say, look, we don't understand what went on under the last Attorney General in terms of the targeting of Mr. Flynn or General Flynn. Yeah. And we need to figure this out given these allegations that are out there that are credible, based on government documents. It's not based on conjecture. It looks like they hid 302 material. It looks like they ambushed.
They said they can't find it. Find 302s. Sidney Powell is alleging that it's clear that someone, obviously a prosecutor or an agent or someone, changed 302s.
Well, the question is, can Peter Strzok be trusted in this area? Because he's one of the interviewing FBI agents. There was an initial meeting with General Flynn, an initial set of notes, and then the 302 that was finalized didn't happen until some time later, and it was on that he was charged with lying to FBI investigators, even though there had been a conclusion early on there was no lying.
By the way,
this is a nightmare in terms of ethics at the Justice Department.
We should point out that conclusion came from Andrew McCabe, who said that who acknowledged that the interviewing agents didn't think he was lying at all.
You know, this was, again, one of the first of the Mueller abuses, and it highlights the crisis of confidence in the Justice Department and the FBI caused by Mueller's misconduct that Attorney General Barr needs to clean up forthwith.
And I want to turn quickly to the farce that is underway in the House of Representatives. The president today saying the Republicans should release their own transcripts of witnesses who've been interviewed. Given what we've seen today, do you think that's good counsel?
Well, they should demand the release of all the transcripts that the Democrats say they have in the lease, because I tell you, when you look at what's being released today, it's a big yawner. You have deep state bureaucrats complaining that the president is being president by recalling an ambassador and being concerned about corruption in Ukraine. But incredibly, you also have confirmation that the former U.S. Ambassador Yovanovitch, had authorized the monitoring of the social media accounts of Americans. Now, she said she didn't know who specifically was being monitored and didn't think that it was illegal. But our reporting suggests that the State Department in D.C. said, stop it because it's illegal. Yeah. Our reporting shows, Lou, you were on the list, including Giuliani was on the list, and Donald Trump Jr. was on the list, a whole host of Fox News people, other journalists.
Sean Hannity, I mean, those guys are really in good company, don't you think?
What was she worried about? That she was monitoring Biden, Ukraine, Soros, Giuliani?
I love the way she answered.
Go ahead.
I just love the way she answered the question when specifically asked about me. Said, was he ultimately monitored? And she said, no, I don't know. I like the no better than the I don't know. But anyway, Tom, it's great to have you with us as always. We appreciate it.
You're welcome.
Tom Fitton, Judicial Watch, and they do great work for this country.
Attorney General William Barr now looking into intelligence assessment, finding that Russia wanted Trump to win the presidency. The review will reportedly look at disagreements among the intel analysts and whether the findings were motivated by political opposition to Mr. Trump. Well, President Trump today accusing the New York Times of providing false stories about his administration to the FBI, tweeting out, "Just revealed that the failing and desperate New York Times was feeding false stories about me and those associated with me to the FBI. This shows the kind of unprecedented hatred I have been putting up with for years with this crooked newspaper. Is what they have done legal?" Joining me now, Tom Fitton, the president of Judicial Watch, which uncovered these shocking emails. So, Tom, surprise, surprise, the anti-Trump forces in the FBI were colluding with the New York Times. What do you make of it?
Well, you know, the emails speak for themselves. I know the New York Times is trying to defend itself today, saying they were just doing journalism. It's an email to the spokesman for the Justice Department from a New York Times reporter describing a story that his colleagues are working on about Jared Kushner and Russia, a story that we know was planted to make Donald Trump look bad and suggest nefarious activities, none of which have panned out, of course. The reporter wasn't asking for a comment. He sent the information along. And so, you know, that seemed unusual. And there's a second email where the New York Times is willing to give the FBI leadership a heads up, a preview on a story. So, you know, if that's journalism, I think Americans would be upset about it because it looks like the media is working with the FBI on getting Trump. And,
well,
you know, and the documents
by the way,
are what
we
they
should
are.
mention it wasn't the entire FBI. Obviously, these are the anti-Trump forces in the FBI who were using their position to coddle up and get stuff out that they knew the press was hungry for, because the press hates Trump or has hated him from the beginning. So they knew it was a receptive audience. Yeah,
and you put it in the context of illegal leaks to the New York Times and the Washington Post, the classified information concerning Russia, the anti-Trump animus. You know, this material came from the cache of documents of Strzok Page emails.
Yeah.
So this is further documentation also that Peter Strzok and Lisa Page were in the center of the Russia investigation by the FBI and DOJ, and was also involved in media relations as well.
And by the way, we should mention once again, as Congressman Nunes has recently, that in October of 2016, Christopher Steele, the guy behind the Trump dossier, met with a Deputy Assistant Secretary of State he came out with information that even though she obviously was not pro-Trump, said was completely false information, like there was a Miami division of the Russian consulate, which doesn't exist. So she passed that information on to the FBI, and the FBI still went ahead full throttle with Chris Steele and using his so-called documentation, which she told them was bad, for their FISA warrants.
You know, and none of that stopped the State Department from other documents we have with continuing to collude with Steele and sending his information along also to the top leadership of the House Democratic Party, Steny Hoyer's office.
Yeah. Now,
you know, and again, going back to your first story, you betcha Barr needs to look at that hit job IC assessment on President Trump. Look. No one knew President Trump was going to win. I don't even know if President Trump knew he was going to win. The idea the Russians, quote, wanted him to win is absurd. They thought Hillary Clinton was going to win, and it looked like their activity was designed to put Hillary Clinton back on her heels as she entered the presidency. The suggestion otherwise, to me, was politics designed to undermine the legitimacy of President Trump's election. And you can look at the IC assessment yourselves. It's publicly available, and you'll see it's as much of a weak tea argument against Trump as the Mueller report. Just IC, intelligence, deep state garbage targeting Trump, created by the Obama gang.
By the way, I'm wondering how much of what Attorney General Barr is uncovering and will uncover will discredit portions of the Mueller report, or at least discredit his inability or unwillingness to look into what was going on, the anti-Trump forces within the FBI.
The received wisdom, even about Russia interference in the election designed to help President Trump, can't be taken at face value. He's got to look at everything that everyone assumes is true. There was never collusion. It's not even clear the Russians were trying to help Trump. They may have well been trying to help Clinton or keep her back on her heels with no idea that Trump was going to win.
By the way, I just want to get your assessment of something. The president today was interviewed. It's going to be shown on Sunday on Meet the Press. But he talked about the whole push for impeachment and Nancy Pelosi's unwillingness to go that route, at least now. Let me just play the soundbite and get your reaction.
Why do you think Nancy Pelosi has held off her impeachment caucus?
Because I think she feels that I will win much easier. I mean, I've been told that by many people.
Do you think impeachment's good politics for you?
I think I win the election easier, but, you know, I'm not sure that I like having it. Look, I did nothing wrong. I was spied on. What they did to me was illegal. It was illegal on the other side. I did nothing wrong. So impeachment's a very unfair thing because nothing that I did was wrong.
You know, I can understand the president. On one hand, politically, it might actually help him, but it is a stain. Nobody wants that stain, particularly if it's totally undeserved.
Well, that's exactly right. And the president obviously is concerned that the coup cabal will continue with an impeachment fight. Even if they lose or even if he wins, it's an abuse of power by Congress even talking about it. There's no collusion, no obstruction, no case for impeachment. And Nancy Pelosi, I think, said something sensible the other day, based on my understanding. She said, look, you know, impeachment is something that's obvious. There's something out there that obviously someone needs to be impeached for. And the idea that the House is going to hunt around to make a case that isn't apparent to anyone else in the country, Nancy Pelosi is a sophisticated enough politician to know that won't wash.
Yeah. Tom Fitton, great to see you, Tom. Thank you very much.
You know, Judicial Watch has been in the forefront of our efforts to make sure that your elections are free, fair, and honest. And we have an election integrity project that over the years has sued in federal court to enforce the law, to make sure that voting rolls are cleaned up, or states take reasonable steps to clean up voting rolls. And we've had a great success in that regard in California, where we just announced this week that we filed a settlement agreement. We signed on to a settlement agreement along with our clients, the Election Integrity Project of California, and some individual citizens out there, with the state of California, the Secretary of State there, and the Los Angeles County, requiring Los Angeles County to take steps to remove up to 1.5 million in active registrations from their voting rolls. And the law we're seeking to enforce, and that we sued under, is called the National Voter Registration Act, and it was famously known as the Motor Voter Bill. It was signed into law by President Clinton, and the deal was this, and it wasn't much of a deal because Republicans objected in large measure to it, but their concerns were overridden, that, look, we're going to have efforts underway to register as many voters as we can. But as a result of those efforts to register a bunch of new voters at DMVs and at welfare offices and things like that, we're going to require states to take reasonable steps to clean up the election rolls. Well, as you can imagine, the left had zero interest in cleaning up election rolls, and obviously pushed hard to make sure that registration numbers became inflated improperly. And sure enough, leftists in the Justice Department during the Clinton administration, the Obama administration, refused to enforce the section of the law requiring the states to take reasonable steps to clean up the rolls. So that's where Judicial Watch came in. We filed the first private lawsuits in American history seeking to enforce that section of the law, that states are required to take reasonable steps to clean up the rolls. And we had successful outcomes in Indiana and Ohio. We had the first state settlement with Ohio, the substance of which was upheld last year by the Supreme Court of the United States. And last year as well, we had a follow-on lawsuit in Kentucky that resulted in a settlement and a consent decree that requires Kentucky to take reasonable steps to clean up its rolls. Kentucky's rolls were an absolute mess. And one of the standards we use is you look at the number of registrations versus the number of eligible citizens there in a jurisdiction or a state that is eligible or are eligible to vote. And too many states and too many counties, especially California, had more people on the rolls than were eligible to vote. That's a pretty good indication that they weren't taking reasonable steps to clean up the rolls. And this is where Judicial Watch came in. We sent the warning letters that the law required, and we sued specifically in California to make sure that the rolls were being cleaned up. And our allegations in California were dramatic and accurate because they were based on census numbers and data provided oftentimes by the states and the counties we were concerned about. Los Angeles County had more voter registrations on its voter rolls than it had citizens that were old enough to register. Specifically, according to data provided to and published by the U.S. Election Assistance Commission, which is a federal agency, LA County had a registration rate of up to 112% of its adult citizen population. 112%. Entire state of California had a registration rate of about 101% of the age-eligible citizenry. 11 of California's 58 counties had registration rates exceeding 100% of the age-eligible citizenry. Now, we're talking California, the largest state in the union. They've got 40 million residents. I think Los Angeles County, their population is over 10 million. And if it were a state, Los Angeles County would be one of the top 10 states in the country in terms of population. And in the course of this litigation, and you know, I should tell you that I don't do the litigation. I'm not a lawyer. We've got a great team of lawyers here that litigated this case, led by Bob Popper, who's director of our election integrity section, integrity project. He was a former Justice Department attorney. He actually worked in the Obama administration for a period of time. And he was former deputy chief of the voting rights section of the Justice Department. So someone who knows what to do and how to enforce the law. And so kudos to our attorneys for filing and litigating this lawsuit, but ferreting out the following information. Los Angeles County confirmed to Judicial Watch that it had on its rolls more than 1.5 million potentially ineligible voters. 1.5 million. Nationally, the total number of people on the rolls that were potentially ineligible, Judicial Watch found to be 3.5 million. Half of the problem was in this one county, Los Angeles County. That meant more than 1 out of every 5 Los Angeles County registrations was probably bad, in the sense it belonged to a voter who had moved, or who otherwise was ineligible to vote, or was dead. We also found out that California, and Los Angeles County specifically, hasn't enforced or removed one person from the rolls since 1998, 20 years. So this settlement agreement, which was filed with the local court and the federal court in Los Angeles yesterday, is now going to have the enforcement of a federal law to clean up election rolls in California that hasn't been enforced in 20 years. This is a major victory for Judicial Watch. It's a major victory for election integrity. It will set a standard and a precedent not only in California for the other counties, but also nationwide, for states to take reasonable steps to clean up election rolls. And specifically, what's going to happen is the new settlement agreement requires that all of the 1.5 million potentially ineligible registrants to be notified and asked to respond. So there's going to go a mailing out to these people. If there's no response, those names are to be removed as required by the MVRA and as affirmed by the Supreme Court last year. Now, they're not removed immediately. It will take potentially 2-4 years to remove these names. But I tell you, they haven't been touched for 20 years. In fact, according to according to what we've been able to, according to what we've been unable, excuse me, according to what we've been able to uncover, over 580,000 registrations who are inactive are over 10 years old. And Los Angeles County was a mess. They had 23% of their rolls, frankly, that shouldn't be there. They're basically going to have to cut a quarter of their voting rolls. And why is this important? Because dirty election rolls can mean dirty elections. When you have inactive registrations on your rolls, it means that anyone can show up and vote in that person's name through absentee balloting and other fraudulent means. And in California, they've made it worse because they've enacted under law this ballot harvesting scheme, which allows third parties who don't know voters to collect ballots and bring them to polling places, which is an absolute recipe for fraud, which is why their ballot harvesting is mostly illegal in this United States. So as a result of Judicial Watch's lawsuit, California is not only, Los Angeles County is not only going to take these steps to take these 1.5 million inactive registration off the rolls, they're immediately, for instance, going to now start, forget about the mailing, they're going to start taking steps immediately to remove dead people from the rolls. Incredible, it took a federal lawsuit to get this done. And in addition, California's Secretary of State is going to notify the others in the state, the other counties, that ineligible names must be removed and that they're obligated to do so. So it's not just going to be Los Angeles County. There are going to be other counties in California that are going to have to start removing names. Now, this does not mean that if you're there in a county and you're eligible to vote and you still want to vote, you won't be able to. If you're an active voter, you'll be able to vote. If you respond to anyone's request for information, are you still there? We haven't heard from you. That's the way to get your votes counted. Maintain your registration. If you don't maintain your registration, you still will be able to vote mostly in many of these places because you'll be able to file provisional ballots. So this is not a voter purge in the sense that, oh, these poor people who aren't voting, who are regular voters, will have their names removed. No, these are people who don't vote and who are likely moved away or dead. And the fact that the left has hated the idea of doing these basic list maintenance procedures, it tells you what their goal is. Their goal is to have the voting rolls padded in a way that allows for potential fraud. That's my conclusion. I don't see any legitimate basis for opposing the cleanup of voter rolls, for opposing voter ID, for opposing citizenship verification, other than the fact you want dirty voting rolls for fraud, you want people who are not who they say they are to be able to vote, and you want non-citizens to vote contrary to law. And the left has made it its mission to oppose Judicial Watch in these efforts to enforce the law on list maintenance, voting roll maintenance, opposing everywhere voter ID laws, and they certainly don't want citizenship verification, which would be a cutting-edge reform and a much-needed reform given the large number of aliens ineligible to vote in the United States. And the left has devoted an enormous amount of resources to opposing efforts like this. They've opposed us in various states. They tried to oppose us in California unsuccessfully. And it's just little old Judicial Watch taking on these behemoths on the left and in the states, the state governments, and getting the work done. And we do it with your support and the excellent legal acumen of our attorneys on staff here. So this is a big victory on behalf of election integrity, and it's going to have national ramifications. And you'll learn more about it in, I'm sure, the coming months and such as it becomes widely known. But remember, we came in and got a law finally enforced in California to clean up the rolls that hasn't been enforced in 20 years. You know why it hadn't been enforced in 20 years? Because the liberals in the Clinton administration convinced California that they didn't have to remove names from the rolls, and they stopped doing so. So if you live in California, as a result of Judicial Watch's work, your elections are going to be cleaner pretty soon. And it's a great credit to our supporters who allow us to do this work as well. And we're going to keep on doing it. We're going to follow up in California to make sure this settlement agreement is enforced. We're going to be going into other states that have egregious list maintenance issues to make sure that names are removed that are supposed to be removed. Look, we don't expect every name that's ineligible to be removed. The law requires reasonable steps. And it certainly is unreasonable not to remove a name from the rolls for 20 years. Especially if half of those names, a third of those names, haven't been active and voted in the last 10 years. Unbelievable. So it's great news. It was great news. This is why I'm pumped for 2019, because I want more successes like this, and I know with our great staff here at Judicial Watch and your support, we're going to have more great success. On top of that, we get this new document from the Justice Department and the State Department. They've been withholding this Clinton email for years, hiding it. Why? Because it confirms the Clinton email cover-up. It's an email that had been sent. Essentially, the email reads, it's a report on WikiLeaks. And the report is redacted heavily. And it's sent to Hillary Clinton and top officials at the State Department. Someone else forwards it on, and includes Mrs. Clinton's private email address that she was misusing for government business. And Daniel Baer, who is an Obama State Department Deputy Assistant Secretary of State, writes to Posner, who had forwarded this email on with Hillary Clinton's email. Baer writes, "Be careful. You just gave the Secretary's personal email address to a bunch of folks." Posner answers, "Should I say don't forward? Did you notice?" "Yeah, I just know that she guards it pretty closely." What does this show? It shows the State Department knew Hillary Clinton was using her email, her non-governmental email, to conduct government business. It shows that Hillary Clinton didn't want many people to know about the fact that she was doing this. It also shows that the State Department covered it up. Why does it show the State Department covered it up? Because they refused to give it to us, even though they knew they had it. We found out about it only as a result of discovery, just recently given to us by a federal court judge. You may recall last December, Judge Royce Lamberth granted us discovery in a Benghazi case that covers Hillary's emails, that the government, the State Department and Obama and Justice Department tried to get us to shut down before they had to fess up on the emails. The judge was furious. He said, I want to know whether Hillary Clinton was trying to avoid FOIA, whether or not you were trying to game the court by shutting this case down so that you didn't have to produce the emails, and where the other emails might be, the ones she deleted or otherwise are out there. And in the course of the discovery he granted to us, a top official at the State Department, or a former top records official at the State Department, testified that he reviewed it in late 2013 and 14. Did you hear that? 2013 and 14. They knew 6 years ago, at least, of course it goes back further than that Hillary Clinton was using government email, personal email for government business. And they weren't telling anyone about it. They were hiding it. This wasn't produced to Judicial Watch. Actually, it was produced to Judicial Watch. It was produced to us previously in a redacted form that hid Hillary Clinton's email, that she had received it, and the specifics that she didn't want it shared with anyone. They hid it from us. It's a cover-up. And we pushed them to give us the complete email that the witness testified about because the court told us just a few weeks ago we can get it. And they were still playing games with us. And they only gave it to us after our lawyers threatened to go to court to compel its release. So the Justice Department and State Department were still trying to cover up from Hillary for Hillary Clinton as recently as 10 days ago. And the Justice Department, you want to know why the Justice Department isn't prosecuting Hillary Clinton? They're too busy defending her. And it's not too late to reopen the criminal investigation into what Hillary Clinton did. Judicial Watch has the evidence. People say, does the Justice Department know? Of course they know. They give us the evidence. So where do things stand now? The court is, we're in the middle of writing a brief responding to Hillary Clinton's opposition to our motion to depose her. Well, essentially, we have asked the court for permission to depose her. The court has already granted us additional discovery because of big fines like this. And Hillary Clinton, while she's out there joking around about her emails, her lawyers are in court trying to tell the court, don't let Judicial Watch question her. Under oath, with the support of the Justice Department. They didn't want us asking any additional questions. Same goes for Cheryl Mills, her chief of staff, then the lawyer involved in helping delete the emails once she left office. We wanted to depose her again. So I presume the court will rule in the next month or two. So the Hillary Clinton email scandal continues. And unlike Congress, which is covering up for her, unlike the Justice Department, which is covering up for her, and the State Department, which is covering up for her, and of course, protecting themselves, there was news this week that the State Department IG, I think, has sent letters around to people who had been using her email account both directly and indirectly because they were sending classified information improperly to her and using the wrong accounts to send classified information, unsecured accounts. And of course, they're all up in arms thinking it's a plot by Trump to resurrect the Clinton email issue. The outrage is they're only doing this 7 years after the fact. And my guess is they're doing it in response to the federal court judge who was furious at the State Department's cover-up, and he excoriated both the State Department and Justice Department for it, not only under the Obama administration, but under the current administration. So things are moving on the Clinton email front because of Judicial Watch leadership. No wonder they want to talk about innocent phone calls to Ukraine. We have documents showing a coup attack on President Trump out of the Justice Department and the FBI, a spy operation against him. You have Attorney General Barr daring to ask questions about the spying on Trump generally. I don't think there will be any prosecutions, but still they're very nervous about it. That's why they're talking about Ukraine, folks. I'm proud to say that Judicial Watch is trying to hold Adam Schiff to account. We filed a lawsuit just a few hours ago in federal court against Adam Schiff and the House Intelligence Committee, the Select Committee on Intelligence, over those illicit phone subpoena records that we've been talking about. We filed the lawsuit in federal court here, as I say. I'm looking for the my notes here. Yes. This is a great headline, isn't it? Judicial Watch sues Representative Schiff and the House Intelligence Committee for phone subpoenas targeting President Trump. And this is the lawsuit. This is what it looks like. It's a complaint against Schiff and the Select Committee. So we issued this, an open records request, and I may have told you about this a few weeks ago, and it's been ignored. We asked for all subpoenas issued by the House Permanent Select Committee on Intelligence on or about September 30th to any telecommunications provider, including but not limited to AT&T, for records of telephone calls of any individuals, and all responses received to the above referenced subpoenas. So what happened is Schiff issued these illicit subpoenas, and they are illicit. They were secretly issued, obviously. No one knew about them. Nunes was told there were phone records that were being subpoenaed, but he only saw some numbers. He didn't know what they were about, and he was in no position to object. And because he was following the rules, he kept them secret because the rules required they be kept secret. So they got the records, and one of the targets was Rudy Giuliani, the president's attorney. So they abused their authority to get into the attorney-client relationship that is privileged of the President of the United States. So on top of subpoenaing the phone records, evidently they were able to look at the records they were getting on Giuliani and this Ukrainian American who's been caught up by the Justice Department. And they started looking at who Giuliani was talking to. And evidently they backtracked the records to Jay Sekulow, Devin Nunes, a member of Congress, as I said, John Solomon, Victoria Tenzing, and a host of other innocent Americans. And they published those records. So they illicitly subpoenaed the records and then published them. Mike Mukasey, who's a former Attorney General, I think under President George W. Bush, he was on TV the other day and he suggested it could be a crime to have gotten these records. Certainly they were violative of the president's civil rights and the privacy rights of the Americans whose records were published in the Schiff fraud impeachment report, the coup report. So what Judicial Watch says, well, how do we figure out what went on here? Now, Congress typically isn't subject to the Open Records Law because the Freedom of Information Act that we use all the time it does not cover Congress. They're not subject to FOIA. So when you hear about the president being impeached because it's not transparent, he's not supposedly transparent enough for them, there's no law, federal law, that specifically requires them to be transparent. But there is a common law that requires them to be transparent, and that's what we sued under. The records are of critical importance as the subpoenas were issued without any lawful basis and violated the rights of numerous private citizens. Disclosure of the requested records would serve the public interest by providing information about the unlawful issuance of the subpoenas. The requested records fall within the scope of the public's right of access to government records as a matter of federal government law. And I'm going to read my quote because I sometimes forget what I say in the releases, and it's really good in this case. Adam Schiff abused his power to secretly subpoena and then publish the private phone records in potential violation of law of innocent Americans. What else is he hiding? Schiff and his committee ran roughshod over the rule of law in pursuit of the abusive impeachment of President Trump. This lawsuit serves as a reminder to the congressman, Mr. Schiff, the committee, and Congress that they are not above the law. Everyone's saying, no, President Trump's not above. They think they're above the law. And Judicial Watch's motto, by the way, our motto and our motivation is because no one is above the law. And I know you say, well, Hillary Clinton's above the law. Well, they may think they're above the law, but we have to operate as a society that no one's above the law. And in the case of the President of the United States, he's not above the law, but he's not beneath the protection of the law, which is what the Schiff scheme is about. Denying the President his due process rights and invading his privacy and the privacy of anyone who dare opposes Adam Schiff. You think the phone records he has are limited to the people I've been talking about? Don't you believe it? Who knows what other phone records he has? Does he have my phone records? Does he have your phone records? Who knows? And the House isn't going to do anything about it. The Senate majority, Mitch McConnell, he's got a very different approach. He doesn't want anything to do with Schiff coming into the Senate and testifying, as we've discussed. I think there's opportunity. I think they should do that. My guess is the president would be happy to see that. So I don't know how that's going to work, but Judicial Watch doesn't rely on Congress to do the right thing or to get to the full truth. We do the heavy lifting on that because Congress often fails to do that. And I'm proud of this new Schiff lawsuit. We thought of a way to try to get accountability, a way that no one else thought of. And to the degree other people were thinking about it, they're too afraid to act. And because we have the strong support of you, the American people, we're not afraid to act.